This week, Robo Lawyer, we're going to be talking about the remedies, where directors have breached their duty and what remedies are available and what are the consequences of that. And we actually look at 3 chapters this week, chapters 14, 15 and 16. Now, chapter 14, we look at how the duties are enforced where there's been some person's done something wrong, and generally, that's right, lawyer. ASIC, the Australian Securities and Investments Commission, can enforce remedies, impose penalties. Now that's quite important. We talked about the civil penalty provisions, and they're spelled out, and the chapter deals with the types of outcomes which can come from that, including disqualification order, pecuniary penalty, those sorts of things. But we also talk about prescribed offences and offences where the penalty isn't set out in the legislation. It might be set out at the end in Schedule 3. That's right, Robo Lawyer. I put a note up on the announcements page, of course, so that we're telling people to look there, because what's that, Robo? It's helpful with the assignment question 3. Yes, indeed it is. So that's very important. We need to make sure people know about that. So, but basically, the statutory duties are enforced by ASIC, and the general law duties are enforced by the company itself, and we have separate remedies there for breach of general duties. And yes, that's right, Robo. Section 184 of the Corporations Act actually turns some of those civil penalty provisions into criminal penalties if they are if the conduct is sufficient to warrant that, and that can occur as well. So overall, we need to be aware of a number of different things. We need to be aware of the penalties spelled out in legislation for failure to comply with all different sorts of sections, all through legislation. It might talk about prescribed offences and other types of offences. Then we talk about the civil penalty provisions. Again, they and therefore breach of statutory duty. And they're set out there in the legislation. They say something of civil penalty to let people know. And some of the civil penalty breaches can also amount to offences. They're criminal offences. And then the breach of general law duties, they're enforced by the company itself. So that's fairly complicated in some ways, but if you get it clear in your mind, ASIC does the statutory duties, and the company itself can enforce the civil or general law duties there, and the civil remedies there. They're in nature of things like an injunction, compensation, account of profits, yes, a rescission of contract, or holding the defaulting parties ordered to hold property on constructive trust. Sometimes the person in breach can actually be granted by relief by the court, so it doesn't necessarily mean that it's going to go through, and in some cases, if you have a look at section 1317S and 1318, there is a provision there for a person in breach to avoid liability. The other way a person can avoid liability is if the company ratifies. What does ratify mean, Robo? Well, that means where the company in general meeting approves or endorses the conduct which would otherwise constitute a breach. So directors just can't ratify. It's got to be a general meeting of the company, and there's got to be full disclosure made to it. The last point, what about the insurance? Well, insurance comes about just like in the partnership. Partners can take out insurance. Well, yes, the directors can and officers can take out insurance, but the law gets complicated there because it's sometimes it's got to the stage where the company can actually indemnify, or could indemnify, a director if the director had breached duty to the company, and the law says that's not permitted, sorts of. So there's a whole complex area there about directors and officers' indemnity. So that's basically chapter 14. But chapter 15 looks at what remedies are available to the members. And the interesting things there are, if the members of a company feel that they have been badly treated, what's that robo-lawyer? They can sell their shares and get out. Well, in a big public company, that's the way to do it, especially if the public company is listed on the Australian Securities Exchange or some exchange. It's very easy to sell the shares, but in a smaller company, sometimes they can't. So they have a statutory remedy for what's known as oppression, where members of a company are oppressed by the majority, and the members can apply to the court for remedies there. And that's the oppression remedy is found in part 2F, and it talks about what sort of remedies are available, because when the court decides there's been oppression, it can make a number of orders which are appropriate, might be appropriate in the situation, like ordering that the members' shares be transferred. They can order injunctions, they can order the constitution to be altered. So it gives quite a range. Sometimes they might also say, look, things are so bad with the company that the company should be wound up. Winding up is where the company comes to an end. In some cases, that's the only way the matter can be satisfactorily resolved. Now, it's quite often the reason they give it's just and equitable, winding up on the just and equitable ground, if that's the case. So there's a number of remedies available for a member of a company who feels that they've been badly done by. The court also gives some other rights, the right of members to inspect books. Oh, what's that, robo-lawyer? You're really worried about certain things. Oh, here's Angela Learning. Angela Learning's up there. See Angela Learning. Your Angela Learning's worried too. The company has to bring an action against directors who have breached their duty under the general law. Okay, yes, I follow it. But the directors decide whether the company brings the action, and they're not going to decide to bring an action against themselves. Oh, you two are very clever, you've worked that out. In fact, that's always been a real problem so what they have created is what's called a derivative action, which allows a member to bring an action on behalf of the company for wrong done to the company. Now that's conceptually, that's quite a step forward, because it means that the members acting on behalf of the company, it's not the wrong hasn't been done to the member, it's a wrong which has been done to the company, so they have derivative actions. And that's set out in part 2F.1a. It's derivative actions, statutory derivative. So, where's that pencil dog? We haven't seen pencil dog at all, have we? Now, the last point was the reporting requirements, and I'm not sure how long we've talked for. So, I might have to, I might just stop it there. We'll upload this one. Okay, we'll stop it now. You right? Oh, there's pencil dog. pencil dog's been hiding over there. I hope you've been listening, pencil dog, about derivative actions and all those things, because that's all very important. And I'll stop it. Stop it now. Yeah.